The record should reflect that we are outside the presence of the jury at this time. I've been informed that one of our jurors, juror number 872, is having some tooth pain. She broke a tooth over the weekend. And so what I'm going to do is allow her to go to the dentist to have that addressed. She's called somebody, and they told her it would take an hour and a half to 2 hours. So we'll just take a long lunch break and have everybody come back at 1:30. So I'm going to bring the jurors in, tell them what's going on, and then allow them to go to lunch for a few hours, a little less than a few hours. All right? Okay, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury has joined us again. Members of the jury, one of you is having a lot of tooth pain as a result of a broken tooth that apparently happened this weekend. And she's been a trooper this morning, but the pain has increased. And so with my permission, she has made an appointment to get that fixed. So what we're going to do is take a break so that she can do that, and then have you all come back at 1:30. It'll just be a long lunch break for all of you. Since we're taking almost 3 hours for lunch, I want to make sure that you're clear that the advisements that I've been giving you throughout the trial continue to apply. All of them are mandatory. All of them are extremely important, and all of them apply to each and every one of you. So please continue to abide by all those advisements. At some point in the next couple of days, I'll give them to you again in full, but I am comfortable that all of you know them by heart now and understand how important they are. So let's take a break, and let's have you back here at 1:30, okay? Let's have you back a little bit before that if you can, so that we can start right at 1:30. So why don't you plan to be back at about 1:15, okay? 1:15 or so, no later than that. Thank you. The court will be in recess. The record should reflect that the jury has exited the courtroom. Please be seated, everyone. Since we have a little time, Ms. Nelson, is now a good time for you to make further discussion on the three cases that you cited on the issue of injuries. That there were two cases from Colorado and one case from the Wisconsin Court of Appeals. I read all three cases. I read them over the weekend, but I promised you last week that if you wanted to make a further record with respect to those three cases, that I would let you do that. So
Thank you, Your Honor. I don't think I have any additional argument with respect to the Wisconsin case or with respect to that issue in particular. I did want to make an additional record. Obviously, now that the court has had an opportunity to review the two cases that I cited that have to do with evidence that is introduced for the purpose of establishing issues or facts that are undisputed. I cited those cases to the court simply to provide the court with some authority for the argument that I had previously made, that that is pertinent to the court's inquiry into the probative value of evidence. In other words, if the evidence is being introduced for the purpose of establishing a fact or an issue that is not in dispute, it has very little probative value. So that's the reason why I brought those cases to the court's attention. I wanted an opportunity, in addition, to make a supplemental argument with respect to that issue in particular, which had to do with the prosecution eliciting testimony from a number of victims concerning their ability to recognize the sound of gunshots and whatnot. Because I failed to cite to the Eighth Amendment to the United States Constitution and Colorado Constitution Article 2, Section 20, and I wanted to make sure that I cited those constitutional provisions with respect to that issue. This, as the court is well aware, is a case in which the prosecution is seeking the death penalty, and if there is a conviction in this case and we proceed to a sentencing hearing, the jury is going to be given an instruction that they can consider evidence that is introduced during the merits phase of the trial at sentencing. And I'm sure we will have some discussion and argument about the limitations of that consideration. However, not only do we believe that introducing repeated testimony, cumulative testimony that bears upon undisputed issues in the case violates 403 and due process with respect to the merits phase of the trial, but we also would object under 403 due process and Mr. Holmes' right to a fair and reliable sentencing proceeding under the Eighth Amendment and Colorado Constitution Article 2, Section 20, with respect to the admissibility of that evidence and the jury's consideration of it during any potential second phase of the trial or sentencing phase of the trial. So I just wanted to make that additional record citing those constitutional provisions for the court.
I don't remember a discussion about the last part of the record that you just made. I remember the discussion related to injury. We've had quite a bit of discussion on that. I don't remember an argument or an objection to cumulative in terms of the sound of gunshots and whether victims recognize that sound. I know that there have been objections to witnesses being able to state what their background is. For example, having a background in the military and being able to rely on that background in order to testify that based on that background they could tell what they were hearing were gunshots or that it was coming from a specific type of weapon. The objections, as I have understood them and as I remember them, have had to do with the relevance of the question with respect to the background of the witness. I don't recall having a discussion about cumulative in terms of that specific issue, in terms of the specific issue about the sounds of weapons that may have been used or that were used during the shooting.
That was the issue that I was referring to. I may not have used the phrase cumulative or the word cumulative in making that initial argument, but the reason I'm bringing this up again and citing these additional constitutional provisions was because part of my argument with respect to that testimony is that the fact that gunshots were fired in the theater, the type of weapons that were used, those are facts that are not disputed in the case. And so that was what the additional authority went to, right? And the argument is that that testimony from the witnesses on that issue of recognizing the sound of gunshots and how they're able to recognize those sounds is going to an undisputed issue in the case. It therefore has little probative value and it's inadmissible under 403 in due process.
All right. Again, I don't remember a cumulative objection with respect to that, but if you have an objection to a question, you have to make it at the time the question is asked. I have ruled on the objections that have been made. The issue that we have been discussing has to do with the injuries. So to the extent that this argument is related to that issue, I understand. To the extent that this is a separate objection, it's untimely because the witnesses have testified now. It may apply to witnesses who have not yet testified, but I cannot do anything about it with respect to witnesses who have testified already. So, do the people want to respond, Mr. Orman?
Your Honor, the defendant's lawyer keeps talking about matters not disputed. And I've seen the cases that she cited, which it seemed to be mentioning that in somewhat of an offhand fashion. And I still don't understand really what it's supposed to mean. It's not disputed. Does that mean in closing argument we can say, oh, it's not disputed, but that's not a fact in evidence. The facts in evidence are the evidence that is presented by witnesses through testimony and the real evidence that is presented and the photographic evidence that is presented. And by real evidence, I sort of mean it in the technical sense of physical objects that are presented to the court. It seems to me what they're saying is they're not disputing that the defendant went into the theater and shot all these people and killed these people. Well, okay, fair enough. Although, frankly, Your Honor, the opening statements I heard did not specifically say that. In fact, Ms. Spangler described the defendant as the only quote-unquote suspect. She didn't describe him as the person that did it. If they'd wanted to really not dispute things, they could have got up and they could have said, this is what he did and this is what we're saying what he did. They didn't do that. They danced around it in opening statements for whatever reason they have, and I'm not saying that they should have done an opening statement in any way that I think they should have done it, but they didn't do that. Additionally, Your Honor, regardless of whether they dispute that their client is the only person that went in there and shot these people, the manner in which he did it, the order in which he fired the guns, the number of shots, the speed of the shots, the way that the gun was held, where the people were shot, the type of injuries, and what they heard and observed are not something that I think can be not disputed. When they say not disputed, what they mean is they don't like our evidence and they don't want us to present it. Well, I think it's important that the jury considering this case, considering whether the defendant is guilty, needs to hear all the evidence that they can hear from the people that were there and what they observed and what order the guns were fired in and how many shots were fired. And even if they say, okay, one person has described that, well, everybody in this courtroom knows, at least everybody that has done trials in this courtroom knows, that witnesses have different perceptions of the facts. One witness can come in and say, I heard this. Another witness can come in and say, I heard this. When you have an auditorium filled with about 400 people, you're going to get some very different perspectives. That may be based on experience, that may be based on stress, that may be based on where they were sitting or what they were thinking about or who they were with and concerned about and so forth. You're going to hear different perspectives. The jury is entitled to hear that. And frankly, Your Honor, I don't know what could not be in dispute about that. Frankly, the jury is the one that has to determine what the facts are. I don't determine what the facts are. The defense attorneys don't determine what the facts are. And with all due respect, you don't determine what the facts are. The jury determines what the facts are. And the way they do that is considering all the relevant evidence. And the fact that two people can hear different things from different perspectives, I think by nature, Your Honor, indicates that it is not cumulative in any way, because at least the evidence I've heard, people have differences in what they've observed, what they've heard, what they saw, what they smelled, and that is all part of the human experience of encountering situations and recounting what they have observed. So I think that the defendant's assertion that he doesn't dispute things is not actually the facts of this case. The facts of this case are we need to prove what happened, and that's what we're doing. And unless you have any questions for me, Your Honor, that's all I got to say.
No, not at this time. Ms. Nelson, anything else from you?
Your Honor, in any criminal case, there will be issues that are disputed and issues that are not. I think we have all been litigating this case for 3 years. I think we're all well aware of which issues are disputed. I understand that the prosecution has to prove their case, but they still have to do it in a way that complies with the rules of evidence. We may disagree about where that line is drawn, but the defense is going to make objections that we believe we need to make to protect Mr. Holmes's constitutional rights.
And you should. But I think there's a difference between saying we don't dispute this particular thing, or we don't dispute that particular thing, and then looking at the bigger picture and determining whether something is really in dispute or not. I have indicated before that I think the nature, character, extent, and severity of the injuries goes to whether the defendant intended to cause the death of all the surviving listed victims in this case. And that issue is not undisputed. The issue about whether he intended that is certainly in dispute in this case. It's very much in dispute. Similarly, the issue as to whether the defendant acted under circumstances evidencing universal malice with extreme indifference to the value of human life generally, that issue is very much in dispute. The issue whether the defendant knowingly engaged in conduct that caused grave risk of death to others, that's very much in dispute. The issue of insanity is at the heart of this case. And insanity under Colorado law requires the prosecution to prove beyond a reasonable doubt that the defendant was not insane. And as you know, one of the tests for insanity under Colorado law has to do with whether the defendant suffered from a mental disease or defect that prevented him from forming the culpable mental state that is an element of a crime charged. And I just talked about a couple of those culpable mental states that are involved here. I just talked about intent, and I just talked about knowingly doing something. So to the extent that this evidence goes to intent, to the extent that it goes to universal malice, manifesting extreme indifference to the value of human life, to the extent that it goes to knowingly engaging in conduct that creates a grave risk of death to others, then it also goes to the issue of insanity, that's the case. That's what this case is about. And that issue is not undisputed. But beyond that, I agree with Mr. Orman. What I remember from opening statements was statements that were made carefully. And it almost seems like you're trying to ride two horses. On the one hand, you're not quite conceding that the defendant committed the shooting. On the other hand, you keep saying this is not disputed and the only issue in dispute is insanity. And what I remember hearing from Mr. King's opening statement was that there's no dispute that the shooting occurred. And then he said something like, the defendant has pled not guilty by reason of insanity, so he has essentially conceded that he pulled the trigger. That's at best qualified. Essentially, conceding means basically or kinda or pretty much. And then Mr. Orman indicated what was said during the second part of the opening statements by Ms. Spengler, which is she said he was the only suspect present. So that there's not even a clear concession with respect to the act of the shooting having been committed by the defendant. And so these are issues that are very much in dispute, and the prosecution is entitled to prove these elements and to meet its burden of proof however it feels it needs to do it, so long as it is within the rules of evidence. If there is an objection to cumulative, then you have to make it in a timely fashion, and I will rule on that objection. But I think that the nature, the character, the severity, and the extent of the injuries goes to all these issues, and I've tried to set parameters that are reasonable. Generally speaking, I think what I have allowed is first, I've allowed the surviving listed victims to talk about the appearance of the wounds or injuries as they happened while they're in the theater. Second, I have allowed a brief description of the injury that was actually diagnosed by medical personnel. Third, I have allowed whether hospitalization was required, and if so, where and for how long. Four, I have allowed evidence as to whether surgical procedures were required to address the injuries, surgical or other similar procedures. And then finally, the result of the injuries. Well, what is the result after the medical intervention? What is the result? What is the injury, the permanency of the injury included in that? And it's been brief what I have allowed. And when one witness tried to go into how a year later he started losing weight and he was having mood changes and that was affecting him, I stopped him and I said that goes too far. Similarly, if a witness wanted to talk about how in the hospital after the surgery he had to be placed on a specific diet because of the anesthesia and that was making him sick and he was in a lot of pain, those kinds of that kind of testimony would not be allowed. But I think in order for the jury to get a fair, accurate, and complete picture of the nature and character of the injuries, the extent of the injuries, if you will, they have to have the information that I'm allowing. And so to the extent that the prosecution is introducing evidence for the purposes of fairly and accurately painting the picture of the injury or describing the injury, it's fair game. To the extent that it goes beyond that, or to the extent that it is being introduced simply to draw the jury's sympathy, then it's out of bounds, and that will not be allowed. So those are sort of the parameters that I have said, and what the prosecution has to ask itself before questioning witnesses is, how do we fairly and accurately describe the injury to the jury? That's the question, because that's what they're allowed to do, and that's what I think is relevant to the issues that I have mentioned. So, all right, with that then, it's 5 till 11. I'm going to take a break, and Ms. Nelson, sorry, was there something else?
No, Your Honor, and I understand what the court is saying, and I just wanted to make clear that this whole issue about undisputed facts really goes to the second argument that I made last week about the victims and the fact that they have military training, and that's how they're able to recognize the sound of gunshots in the theater. And, you know, we're making this argument about the facts that are not in dispute with respect to very specific issues. And so it's the specific issue that we're not disputing, that gunshots were fired in the theater. That's what, you know, we're objecting to that specific testimony, or we did object last week to that specific testimony as to that specific issue. And so the argument that I was making about the undisputed facts, it really had to do with that specific issue and not so much the injuries. I just wanted to make that record clear.
Okay, so you're not arguing that in terms of the injuries, that the injuries should be, the testimony and the injuries should be limited because the facts that the injuries are relevant to are undisputed?
No. We are making an argument that the injuries, the testimony about the injuries should be undisputed. But I don't specifically recall, I'm sorry, I may have just completely bungled that sentence. We are making an objection with respect to the extent of the testimony about the injuries. And we are making an argument that the testimony about the extent and nature of the injuries should be limited in some fashion, and that at some point it crosses the line and violates 403, due process, the Eighth Amendment, and Colorado Constitution, Article 2, Section 20, because the risk of unfair prejudice substantially outweighs its probative value.
Where do you think the line should be drawn? Do you think it should be limited to just what the witnesses observed in the theater? For example, we had a witness who said, all of a sudden I felt a burning sensation in my leg, and I looked down and I was bleeding profusely and my jeans were shredded. Should it be limited to that?
I think it's a case-by-case basis, witness-by-witness issue, but brief testimony about the nature and severity of the injuries. That's about all I can say out of context.
Right, and your inability to articulate exactly where the line should be drawn, I think highlights the difficulty in drawing that line. And I'm trying to do the best I can in drawing that line while applying the rules of evidence, and specifically Rule 403. In the example that I just gave, I think it would be improper for me to draw the line right there, because that doesn't accurately and fairly describe the injuries suffered by that witness. For example, that witness later found out that her femur was shattered. She didn't find that out on her own. She found that out when she got to the hospital, and it was diagnosed as a shattered femur. And so as a result of that, she needed to have a plate and later 2 rods put into her leg, and she had to be in the hospital for, I think, 30 days, and she had to undergo multiple surgeries. And even now, she says she still is going through physical therapy because she has numbness in her leg. And so the injury was so severe that it damaged her leg to the point that she, almost 3 years later, is still having numbness in her leg, and she has 2 rods in her leg because her femur was shattered. That's a description, a fair and accurate description of the injury. Now, in that case, I made an exception. I let her mention that she was still attending physical therapy, but only because that went to sort of the result of the injury, the end result of the injury, the permanency of the injury. That was relevant because she's still feeling numbness in her leg after all this time. And so I think that's part of the extent of the injury. But generally speaking, I have not been hearing witnesses talk about physical therapy and things to that effect. So again, you're right, Ms. Nelson, is on a case-by-case basis, but it's not an easy line to draw, and I'm trying to do it with the criteria that I have discussed, which is what is relevant is what the people need to present in order to accurately, fairly, and completely describe the nature and extent of the injury to the jury. I can't put it in any other terms, and I've given you the parameters that I've generally set. And it's brief testimony with respect to each of those parameters. It can't be a lengthy discussion. This is not a civil lawsuit where pain and suffering might be relevant. That's not what it's about. And the prosecution is not allowed to try to get the jury's sympathy or to prejudice the jury against the defendant by introducing evidence of pain and suffering just by itself. So I can't do any better than what I've done in terms of the discussion. Now, as far as the gunshots and what witnesses are hearing, again, I think this is a new argument. I'm not aware that this was made before. And to the extent that this objection needs to be raised, then you need to raise it in a timely fashion. But generally speaking, the witnesses that have been allowed to testify to this have given brief testimony about what they heard and what they recognized in terms of those sounds, and that was based on their experience. And I don't think that's improper testimony. That's testimony that goes to the surrounding circumstances of the shooting, and it also goes to some of the elements that I mentioned earlier, all of the elements that I mentioned earlier. I understand that the defense is not disputing the shooting itself, but this goes to issues that are in dispute. And so you can't say, well, we're not disputing the shooting, so therefore you can't introduce any evidence of what the witnesses heard or what they experienced as the shooting happened, because that's irrelevant, because that's not in dispute. I'm considering that, but I still think it's probative. I still think the probative value of the evidence is not substantially outweighed by the danger of unfair prejudice. I don't know what unfair prejudice there is when the jury knows coming into this that there was a shooting. They have heard a lot of evidence about it. And I should add, by the way, that I have given them an instruction repeatedly and will continue to do so about the fact that they should not allow sympathy and prejudice to enter any of their decisions throughout the trial. And I will continue to remind them about that. But this is something that I have been telling them about in terms of advisements. It's something that we spoke to them about in individual voir dire, and so they're prepared for this. It's not like they're hearing it for the first time or watching the evidence for the first time. This is something that we talked to them about in the questionnaire, we talked to them about in individual voir dire, and to some extent, we talked to them about in general voir dire. So I am comfortable that this is admissible. All right, with that, I'll let you go on break. I'll see you back here at 1:30. The court will be in recess. Thank you.